Case number 2020-CF2603, the state of Florida versus Sarah Boone, and now names for the record, beginning with the state.
Dave Cacciatore on behalf of the state.
William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin back on behalf of Sarah.
Ms. Boone, raise your right hand to be sworn. Please, do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Ms. Boone is seated at counsel's table, buttressed by her attorneys, wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel?
No, sir.
Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is, you did a market before, so there it is. Okay.
Right now, their ID as AB, Elizabeth and EC
Defensive identification AB, Judge, which is the it's a no contact order. The jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do we want to do that now before we bring the jury in?
I don't have a problem with that. If you want to
Okay.
rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders.
Okay.
And that way we don't have to do a in and out, and I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at the juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised, we'll use our time accordingly.
That one of the six.
I don't
Is that an
believe
alternate,
so. Give me a moment and I can check. That is an alternate. It's alternate seat 4.
Thank you.
Defense, do you have any motions?
Just out of abundance of caution, I would read new or motion for judgment of acquittal pursuant to the defense resting. I'm going to do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge in the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders, pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment, and I'll get those out right now. Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good. All right. Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
Jury's entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there, okay? All right, thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
The first is defense exhibit 19. We'll just review it and pass it down. Next document is defense exhibit 20.
Thank you, members of the jury.
Thank you.
Yes, sir.
Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rests.
Thank you. Defense, or State, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
State of Dr. Tanya Warner.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tonya T-O-N-I-A Warner, W-E-R-N-E-R.
All right, thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law, so anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have,
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Question. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase, and that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work. So controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence, and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant.
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yep.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just to make?
Just, if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink. but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there. And completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him, and as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And, sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
To refresh your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out, and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to you's consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory, it can affect your reactions, it can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5, TR, or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Judge, if we could approach the bench.
Yes. Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you. Y'all can be seated, thank you. Mr. Owens, if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions, and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24, as it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7 for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnosis after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point, if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now, and that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript, I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, That's how she answered. She goes through a little bit of that. And then, paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That
Judge,
was,
excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
all right, page 46. Line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What
I
are
will
the
be
legal,
notified of
what are
any
the
changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well then, my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing, and once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a
I understand that, but
definitive
that's
no.
not the state attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not
Okay,
apply.
that's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable, it doesn't matter, because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer, 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified if there was going to be a change in. And not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be.
I'd have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course. Court's going to step off for a moment while Madam Court Reporter is able to provide that readback.
Thank you, Your Honor. All right, Sergeant Hayes. Instead of showing the picture of you on the tractor, I want to go back. I noticed something you said yesterday regarding, or maybe it was 2 days ago. I've lost track of time. But regarding the tractor, I believe you said, and that's why you were sitting on it because you and me aren't the tallest guys in the world, that it was in the furthest back position.
Yes.
How did y'all figure that out?
I was out there with some investigators from the district attorney's office at the time, and I believe they attempted to adjust the seat and determined it was all the way back.
Okay, and so y'all's method of kind of testing out whether anybody could touch the foot pedals that was short was they had you sit in it.
Correct.
But, you're taller than Melody.
I believe so, yes.
Okay, all right. Because you're what? Did you say about 5'7", 5'8"?
5'6".
Okay. But still taller than 5'3", somewhere in there.
Correct.
All right. But y'all tested and verified. I mean, it was in the back position.
Correct.
All right. I want to go back to 2018 into 2019 and talk about, again, your follow-up investigation with Chris and Scott. I went back and counted your phone calls with Chris and Scott, and there was a number of times that they would reach out to you, yes?
Yes.
Right. And would it shock you if you had 6 phone calls with Chris Farris in 2018, 2019?
It wouldn't shock me.
Right. And you had also were you aware that Scott called 911 about 6 times on Melody?
I knew there were some 911 calls involving the...
Do you remember anything about those? Because it looked like a lot of those kind of got routed over to you.
I don't recall Scott calling 911
Okay.
per se. I don't know if I was involved in those. I know there's some allegations that were made between the family that were routed to the sheriff's office, and given the situation, we routed them to another agency to investigate them.
And that was Woodstock, right?
Correct, Woodstock Police Department.
What were you seeing about the kind of the difficulties going on between Scott and Melody through 18, 19? And Chris, for that matter.
There's definitely some contention.
What do you remember?
Tension between everyone, fingers still being pointed at each other, I'm pretty sure. Arguments.
Do you remember any specifics of these arguments? Do you remember that Scott was alleging that his mother was going through his stuff in his apartment? Do you remember any of that stuff?
I do recall that, but again, once we would get the allegations, we would try to stay out of it and let a third party investigate it due to the investigation we were currently running.
All right, but to your knowledge, Scott was, and then there was some threats that were alleged that Scott made against his mother.
Yes.
To your knowledge, Scott was never arrested, correct?
That's correct.
All right.
Ms. Boone is seated at council's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony?
Yes.
Okay, you may proceed.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. That the answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay, my question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when a question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question was, what the response was, because it didn't. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent with.
You asked to approach. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer, if BSS or PTSD has any, can you reread that so I can?
Let's just reread the entire proffer, just so that it's a clear, soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind.
What I just read.
Yes, ma'am.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
You ready, Madam Court Reporter?
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me. Go ahead.
The very last question?
My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Okay. Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be, Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was, irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me
What?
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had, that she, in the pages that I have talked about previously here today, in the pages that I referred to about our agreement that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
No.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the readback of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and/or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition as identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction?
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition, for you, Mr. Owens, to inquire as to those opinions.
I'm sorry?
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation, based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct, that my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically?
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct?
You're aware Sarah Boone's on trial for murder.
That's correct.
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and/or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware, you know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
That standard operating procedure in these type cases, and now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warren, you realize you're in a courtroom,
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all, vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial?
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So, narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome.
Alcohol use disorder.
Alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore with the unrelated matter?
does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek SIR rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Ms. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your SIR rebuttal?
We don't know because I don't know what the state's going to place in rebuttal, but.
That doesn't answer my question. What's the legal basis of a SIR rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant is pursuing.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No, sir.
Anything else, State?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir. Bless you.
Jury's entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
I thank you all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach. Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing, when he got in the suitcase, when she found him, they were enjoying themselves, she zipped him up, they were still laughing, you know, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, you know, there was an imminent risk of harm that she needed to protect herself.
Can we approach the bench?
Yes. Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction, please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you. Y'all can be seated. Thank you. Madam Court Reporter, when you're ready. Yes, ma'am.
There was a question, and then there was an objection.
Just go from, read it from the question, answer, question, objection. Let's just have the, we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time, they were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat. is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
Judge, it's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that, the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, you know, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer, it's not becoming the juror, it is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr.
The prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play, post-traumatic stress disorder. Battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and the answer, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court that there are no more questions. Let's go ahead and bring back in our panel.
Jury's honored.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, you may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and ESS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yes.
You may proceed, sir.
Dr. Warner, good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson?
it was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes,
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
no,
Do you agree you have a right to do that?
yes,
And did you listen to Sarah Boone's testimony in the trial of this case?
no,
You agree you have a right to do that?
yes,
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, you approach?
Yes.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No,
Another question, sorry.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
no,
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct,
So you had the information,
yes,
the documents, you read the documents,
yes,
you read all the text messages,
correct,
and you are going to express some opinions here today, are you not?
correct.
You're going to express some opinions about narcissism, whether or not she had...
May I approach?
Yes. Objections overruled. You may proceed.
Thank you, Judge. Ma'am, is it fair to say, in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure, I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the texts in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition. You-
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes, that's
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it, if you just refer me to the page.
Just a moment.
You got it?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct?
And you agree that any,
Permission to go out here, based on
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
permission to go out here.
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14, my question is at line 21, your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I can
talk,
read my
first
complete
you said
answer.
no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship,
Correct?
and this is in relation to my question about the text messages. You agree?
Yes?
After you said no, you said they had a volatile relationship, and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object, and we need to approach.
All right, members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service. Y'all may be seated. State, anything else?
No, Your Honor, thank you.
Defense? No, sir. All right, we'll see you at 1:30. Thank you very much. Court's in recess.
And you had a number of follow-up interviews. I kind of want to talk about, we talked yesterday that, you, for a while there, you're kind of on your own in this investigation. But as time went on, and after you applied for the warrant, and the warrant was granted for Melody, there was kind of a second phase of the investigation. Would that be a fair assessment?
Yes.
All right. Could you explain that to the jury?
Once the warrants were taken, the district attorney's office became more involved. They started reviewing the case more heavily and coming up with tasks that needed to be completed.
Okay. And some of that was spending time with Scott and Chris, correct?
Yes.
All right. Tell me about the interview that you had with Scott on 9/20/2019. Do you remember that? You spent a number of hours with him at the Sheriff's Department.
I called him in for an interview. You said September the 20th?
Yes, and if you've got your report with you, please take your time, refresh your memory on that.
You have a page number?
I don't. I'm sure it's sort of the back.
Okay, I found it. And what was your question, sir? What do I remember about it?
Yeah, what do you remember about that interview?
I just, asked him to come back in for another interview.
All right. So do you remember that you spoke with him kind of at length? You know, the first part of the interview would have been friendly. It sounded friendly. I think y'all even took a break together.
Sure.
You remember that?
Yes.
Let him go take a cigarette.
Yes.
All right. And but after that, you kind of started to hone in on him as to the issue of, I mean, you kind of looked at him and forthright said, you know, all the bullets on this property are out in your barn. And he said something to the effect of, yeah, that looks pretty bad. Do you remember that?
I don't recall it specifically, but I'm sure it's on the recording.
Okay. And do you remember that, you know, you started to kind of press him on, you know, the use of guns and being on the property? I mean, you've seen the videos that's been played for the jury about him out there with his buddies kind of doing tactical shooting. Do you kind of remember kind of asking those questions?
Yes.
And I believe after that, that's what led to y'all going out and actually scouring the property for these bullets. Is that correct?
Correct.
That would have been the search warrant where y'all went and did that.
Yes.
Right. And that would be the bullets that I believe were testified to that just came in much later.
Yes.
With the expert from the GBI. But you were on. You kind of shifted. You were doing a further investigation into Scott.
Yes.
Correct.
Correct.
All right. And then there was another interview that you didn't conduct with the GBI. You didn't have anything to do with that. But then you followed up again in May of 2020. Do you remember that? What about May 20th of 2020?
I don't recall that one, the May 20th.
You don't recall that one? Is it? I don't know that it's in any of your reports. It was a short interview.
No, it's not in my report. I don't recall it.
Okay. And what you did in that interview, and I'll see if I can refresh your memory
Okay.
so that we don't have to shut this whole thing down and
Sure.
play it for you. You actually kind of had a map of little dots that you were showing
Yes.
Scott. And kind of saying to him, you know, your phone better not be one of these dots.
Yes.
Do you remember saying that?
I do.
Okay. And you were at that point asking more about any revolvers that he'd ever had, any missing revolvers, kind of digging further into his life. You were digging into this fact that he had been previously married and never brought that up. You remember that?
Yes.
Okay. And you also had ascertained that he had a .357 Magnum that he had stolen from him in Columbus.
Yes.
Okay. And you've seen, and I can go get them back out, but you said, you know, you better be telling me the truth because I'm going to call Columbus. Did you ever call Columbus?
I don't recall if I did. I know one of the investigators with the district attorney's office at the time, we looked into it, and I think we came to the same conclusion.
All right. And the same conclusion being there was never a report made of a stolen weapon.
Not that we could find.
All right. I want to talk again about the Colyos. I mean, with the jury's listened to about three or four Colyos, but this was something every day for a year.
Yes.
I mean, just like you get a text message on your phone or a call, I mean, you just get an alert every time.
Yes.
How many do you think there were? I mean, realistically, my guesstimate would be about 1,000 or more.
I would say thousands. Yeah,
Thousands.
between texts and phone calls, yeah.
Okay. So, and you listen to all of them?
No.
Not possible. I know. I mean, and I'll be forthright with you. It's not. We tried. It's
Yeah.
not possible. But there was thousands of phone calls.
Yes.
And out of those thousands of phone calls, there was never a confession. Correct?
Correct.
All right. And the phone call that was played yesterday, that was from 8. I keep doing that. I think it's up there somewhere. The phone call that was played yesterday was from 8/2 of, which let me go back to my list of rusty interviews. Is it gone? Did you read it a little rusty?
I folded it up, put it on the table.
Well, I'll go get it.
It's folded up on my backside, Mr. Weaver.
so the list of Rusty interviews, you guys had gone up on 8/2/2018, right?
Correct. Yes.
Okay. And on that day, that is the day that y'all had given him that warrant.
That's correct.
And so later on that day, that same day, that was the phone call that we heard,
Yes.
the jury heard?
Yes.
And in that phone call, so would you say that was the phone call where Rusty was really pushing her for an answer?
Yes.
Because it sounded that way to the jury.
Sure, it did.
And I was thinking of something yesterday, and I'm just going to say that everybody knows kind of the way I ask questions sometimes can be I don't know what the correct word for this is, but it seemed like Rusty did a better job of interrogating her than you guys did. Would you agree with that?
Well, we never got to the point of interrogating her. It was early in the investigation when we interviewed her, and didn't after that. So.
All right. So, but he was pressing her.
Yes.
All right, and that was within that same, hours of you literally putting a warrant in front of his face that had, was it conspiracy to commit murder?
Yes.
And the other one would have been concealing the death of another?
Correct.
Any other counts on that?
I believe that was it.
You just typed it up?
Yes, it was.
Signed Hayes on the bottom?
No, it wasn't signed. It wasn't signed. The spot for the affiant, which would have been me, was blank, and where the judge would have been was blank.
Okay. Had you ever done that before?
No.
Okay. Whose idea was that?
It was a group. I don't recall exactly who it was. That Monday morning, typically on Mondays, we would have meetings, briefings about the case, and it was a strategy that was mentioned.
So after you were kind of, I think circles have been you've used the word circle, but then you kind of widened the circle back again and went to Scott. Why did you ultimately move away from Scott in 2020 after you'd interviewed him multiple times?
We interviewed him multiple times throughout the investigation. His statements remained consistent. Scott didn't have motive. Even Miss Farris, when we interviewed her, stated that Gary was his gravy train. Without Gary, Scott had nothing.
But by that same logic, wouldn't that have applied to Melody too?
Not necessarily.
Can you explain that?
Like you've stated multiple times in this trial, in Georgia, what's Gary's is Melody's, and what's Melody's is Melody's. So even when there's a will, in Georgia, it can be contested. So just because there's a will, leaving everything to everyone else. Throughout the investigation, we determined Melody was the beneficiary of all of Gary's life insurance policies.
But you would agree with me, by that same logic. If she is falsely accused of murder, then the siblings take the rest of the assets, yes?
I don't know how it would be contested in court after the outcome of this.
But you would agree with me that if she's out of the way because of a murder conviction, then they would stand to inherit everything, yes?
It's possible, yes.
Right, so that's motive, right?
Could be. Yes,
Could be.
Could be.
You heard that phone call yesterday. There was this other attorney before we got in this case, Manny, and he went out and did an investigation. Did you do a follow-up investigation after his crew went out? Because you heard it in that phone call.
I don't believe we did, no.
All right. But it sounds to me like their investigation there was more that was looked into. They actually luminol things that you guys didn't luminol.
I never heard in the phone call him say that they luminol. It sounded to me like they went out and looked what we did, and it was no longer glowing. Melody said at one point in that phone call that it should still be glowing if it's blood, which indicated to me they were looking at what we had done. And I know after a certain point, luminol flashes or blue star even on blood, it doesn't last forever.
Detective Hayes, Sergeant Hayes, you were a detective at the time. Sergeant, I know you've been sitting here, and I know I hinted around at this yesterday, and I'm about to sit down and stop talking to you, and this will be finally over, at least for you. But I do want to know this. You have sat here and watched every bit of the people that were supposed to be helping you in this case. And does it not frustrate you? Just even if you could have, from your very perspective, checked off this box, that's done. Don't you wish that they would have done some better crime scene intake over at the barn?
Knowing what I know now, I wish I could go back and change some things. That's an accurate statement.
Right. You would wish that, they could have luminoled Scott's apartment. Yes?
Possibly, yes.
You just basically anywhere and everywhere, right? In the barn.
Ideally we would have had unlimited supply of Blue Star, which I believe is why the GBI was called in, because we ran out. We just didn't have a lot. To luminol or Blue Star everything, but we just didn't have the resources.
But you wished you had of. Yes?
Yes,
Okay.
At this point, yes.
More upstairs in the house and more downstairs.
I'd have covered the entire property.
Absolutely. Hindsight is always 20/20.
Absolutely.
And I'll ask you this, because of the breadth of this investigation. I mean, it's almost like fighting a war on three fronts. It's almost impossible historically for any country has that hardly ever won a war on three fronts. You had a barn, you had a fire, you had a house, you had three different scenes on the same property, multiple individuals, but it was a three-front war, and that's never really been won until the United States in World War II, best I can tell. So it was a lot. It was a huge undertaking to try to process this case. Yes?
Yes.
Would it have not been beneficial to have all of the assets of the GBI come and take over this investigation?
I don't know if it would have been beneficial to have their help, yes.
Okay. So hindsight being 20/20, that probably would have been one of the easiest things you guys could have done to assist in this large investigation.
Repeat your question. It could have been the easiest.
The easiest, the solution that is designed essentially by the GBI to assist local agencies, that mechanism that they've created, that's all over the state, that they go everywhere.
Mm-hmm.
That would have been the best thing that you guys could have done in that situation to process this crime scene.
We did call them in when we felt we needed help, and they came in and performed the task that we asked them to do, and then we felt like we had the rest of it covered.
So the answer is you wouldn't change anything?
There are things that I would change, but as far as the GBI specifically, I would not have called them in to take over now.
Your Honor, if I may have a moment. I want to just briefly go back over. Judge, can we switch over to the Elmo? One day I'm going to figure out why this is called an Elmo. So these Cellbrite extractions that were put in yesterday, without us going through all these again, there's far more. Let's see if it'll focus. There is far more messages than just these, correct?
Yes.
These were, just to kind of explain for the jury, this is kind of like a search tool, this Cellbrite program that everyone uses in law enforcement. You can kind of winnow away like a topic of message, Can you do something like that?
I believe you can search keywords and
Keywords.
narrow down, search parameters between dates and things like that, yes.
So these, I mean, we're talking about dates that range back to February of 2018, which is what we're looking at here, and we start to move back into September of 2017. These aren't the same conversations. They're
Correct.
just kind of mishmashed together, yes?
Correct.
Okay. I just wanted to clear that up for the jury so that they knew that this wasn't anywhere really close in time, a lot of them to July of 2018.
Correct.
Okay. I believe that's all I have, Judge.
Redirect.
All right, Sergeant Hayes, talk a little bit about Rusty Barton some more. There you go. Was Mr. Barton with his attorney on August 2nd, 2018 when you interviewed him? Oh, I'm sorry. Oh, thank you. You've been waiting to give me away. Okay, Sergeant, did you hear my question or do you need me to repeat it?
Can you repeat it?
Sure. Did Mr. Barton have his attorney present for all of the meetings that you had with him?
He did.
So that would include the 24th and the on August 2nd.
Correct.
And on the 24th, is that when he made the statement to you that Melody told him he is on the burn in the burn pile?
Yes.
And then August 2nd, you spoke with him. That's like less than a week later. Did he recant it on the 2nd?
No.
And you spoke with him at length on the 2nd.
We didn't.
When you're doing an investigation, do you consider the source of where the information you are told by witnesses, do you consider the source of that information?
Yes.
So witnesses who are not on scene but have information about what happened at the scene, do you consider that?
Yes.
And consider where that may have come from?
Yes.
The map that you showed Scott Farris that day, was that his phone, the doc that you were asking about?
No.
When Scott would call you about his mother and what to do in certain scenarios, you said you'd get another agency involved.
Correct.
And did you also inform him that, if you're feeling a type of way, you could always record her if you're concerned?
I did.
Before you met with Scott and Chris on the 20, let me make sure I get the date right for when you spoke with them. Do you remember what date you had that interview with both Chris and Scott?
I don't off the top of my head. I could find it in my reports.
Let's find that exact date. I believe it was the 27th.
I believe my report says July 26th.
July 26th. Is that 2 days after Rusty Barton told you Melody told him he is in the burn pile?
Yes.
You had that information before speaking with both Chris and Scott that day?
Yes.
And you had information that
Sensor that overrides in my mute section that I replaced this one, so I don't know what's going on. All right, sorry about that.
And you had information when you were talking to Chris and Scott, not only from Rusty, but from inside the home, that something happened inside the home.
Correct.
Like a projectile found in the basement.
That's correct.
Okay. And at that time, you also learned about, you had already known about the existence of Rusty Barton because you had spoken to him.
Correct.
And what happened with Ted Wiley back in the day, right?
Yes.
And let me pull up some. We all know we're going to go to the scene view today, so I want to get a little bit of
That's a view of the main house from outside the barn on the property.
So that's what you can see from the barn, looking over towards the house.
Correct, from that view.
Okay, and where my fingers are right here, kind of in the middle, is that the deck of the house?
Yes.
Okay, so would the burn pile kind of be up here?
Yeah, to the right behind the house.
And now I'm showing you Hayes 60. What are we looking at here?
An overview of the house, an aerial view.
Okay. And I'm going to pull out S. Farris 11. Oops. There we go. These are different angles. Hayes 60 and S. Farris 11 are different angles of kind of the same aerial view.
Yes.
All right. This pin that Mr. Farris put in, is that where you recall the burn pile to be?
Yes, roughly in that area.
So would that be up here somewhere? On Hayes 60?
Yes, I believe
Here,
it would be
do
up.
you want to go put a pin in it? I'll do a black one. Where you recall it to be as well.
Right in this area.
As you were listening to the Collios throughout this case, did it become apparent to you that Mr. Barton may have told Ms. Farris that he was recording her?
Yes.
How did that become apparent to you?
When she questioned him about it, in the beginning, she flat out asked him, "Didn't you tell me that they gave you a recorder?" She told him exactly what we did. We gave him a recorder to record her.
That's all I have. Thank you.
Anything else, Mr. Weaver?
Nothing else.
All right, you can sit down. Thank you, sir. All right, you have another witness?
We do.
We
I
need to
make sure
take
she's
outside
here
the-
at 9 o'clock, so I'm going to make sure
All right.
she's here.
Do we need to take up
And then-
anything outside the jury before
Yes.
that? All right, so, all right, we're gonna go ahead and break for, it's gonna be, at least be 10 minutes, so y'all can go stretch your legs. It means I'm dead.
Is that what that was?
Yeah, it means I'm not.
No pulse?
I don't have a pulse. That's a
7 years. Contents of the device.
Issues we need to take up. We also had a little bit of a technology issue that we're trying to address. I also fixed my sensor that overrides my sound blocking, and as a sanction, I will take my phone from myself and I'll confiscate it. All right. All right, go ahead, Ms. Frankish.
Ms. Harris, if you could please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If you could please introduce yourself to the jury.
I am Lindsay Harris.
Ms. Harris, where are you employed?
I am employed at the Cherokee Sheriff's Office.
And can you actually spell your first name for Mr. Cox since it's spelled different?
Lindsay.
Thank you. And how are you employed with the Sheriff's Office?
I am the commander of the Intelligence Division.
What does that mean?
So I run a division that encompasses intelligence analysts who provide investigative support, digital forensic analysts who extract evidence from devices, and crime analysis.
How many people are in your unit?
10 total.
Can you tell the jury a little bit about how you came to be in that position, your education background, trainings, all of those fun things?
Sure. I have a bachelor's degree in criminal justice with a concentration in forensic behavioral sciences. I have a master's degree in public administration. I began my career as an intern with the Drug Enforcement Administration, which took me into a federally run drug task force where I was an intelligence analyst for over 7 years. After that job, I became the first intelligence analyst at the Cherokee Sheriff's Office, and that was approaching 7 years ago.
Do you, as an intelligence analyst, do you do continuing education, trainings, and those types of things to keep up with the latest technology?
Yes.
The digital world is constantly evolving. So about how many trainings do you go to a year?
It's hard to approximate, but I mean, we're training constantly. I could say on average, I at least I go to one class a month at minimum. Of course, varying hours, but I attend week-long conferences annually, and we're always trying to keep up with the emerging technology.
What kind of certificates do you hold in your field?
I am a certified criminal intelligence analyst with the International Association of Law Enforcement Intelligence Analysts, also called IALEA. I am a certified cybercrime intelligence analyst, as well as a real-time crime professional.
Are you trained in certain softwares that assist you in analyzing digital evidence?
Yes, we use various softwares and programs throughout the course of our work, and we constantly train on the changes in technology again and how these systems can assist us. These systems are, law enforcement databases, open source, and softwares that can read certain records.
What does open source mean?
Open source would be social media, anything that you can use as a plain citizen, and then closed databases would be that of law enforcement only.
Some of these databases require purchasing the software, and then others you can just download on the internet.
That's correct.
And you've used a range of those types of softwares?
Absolutely.
Depending on what kind of evidence you're looking at?
Yes.
I want to talk about Celebrate. What's Celebrate?
Celebrate is a software, and it's actually physical software that extracts the data from devices, whether it be a computer or a telephone, cell phone, and it extracts all the contents of the device.
What software program do you mainly use to analyze digital evidence, personally?
We use a system called PenLink. It's a software that you receive records in various formats. So Celebrate is one way of obtaining a record because it produces a report from the contents of that device. So that report then has to be analyzed. So we use software that we can ingest this large amount of data, and it kind of decodes it in a way that's understandable for us to analyze.
Have you ever testified as an expert before?
I have.
About how many times?
Twice.
At this time, the state moves to admit Ms. Harris as a digital forensic, expert in digital forensics, acquisition and analysis.
Just very simple, the things we've discussed outside the president's jury, the limitations that have been described by the court.
All right, she's an expert and can testify and give her opinion based upon her expertise. All right, go ahead.
I'm going to actually kind of show an example. We've talked about reports, and we have already admitted a few, so I kind of want to go over those with you. Is this a Celebrate report?
Yes, this is a PDF version of what the system Celebrate produces.
And when you receive a phone and it uploads, I don't know what it just did. And it gets.
It's going to do that every day.
I know.
Because you won't click the box that says stop doing that.
Next time I'll catch it. Okay. So we see Celebrate up here in the right-hand corner, and then does it automatically produce the summary and source extraction boxes typically?
Yes, many of those are mandatory fields. Some fields can be added in that would give, examiner's name, but those you see there are mandatory fields.
Okay, and then the content actually within this can be selected how?
So, based upon the parameters of the search warrant, the contents of the device are extracted, and within each report you can seclude some information. If you're just looking to analyze text messages at that moment, you can click through and just seclude text messages rather than everything in the device.
Okay, I want to start with the basics. During an investigation, detectives or investigators seize digital evidence in forms of cell phones, records from companies, all sorts of stuff. What happens between them obtaining these from either the person or the company? How does it get to you?
So records, again, they come in various formats, various time zones. So when the investigator receives the records, they're not easy to understand. They come in formats, they could be a text file, they could be a PDF, they could be Excel. And the investigator doesn't have the ability to quickly look and see what the information shows. So in turn, they ask an analyst, and they send the records or provide it to us and in a digital format in which we begin our analysis.
So let's start with records, and then we'll move to physical devices.
Sure.
When you obtain records from a cell phone company, give an example of what it is that you're looking at and what you do with that record.
So phone records or call detail records is I believe what you're speaking of. So we receive call detail records from the provider. This is your typical T-Mobile, Verizon, AT&T. These records, dependent on what is written in the search warrant, they provide you essentially the transaction data. So this is going to show you the date, the time, the direction, the duration of the call, and then the source, whether it is a phone call or a phone. And again, based upon the parameters of the search warrant, you could receive a cell site location with those records.
What is that dependent upon?
That's dependent upon the wording of the search warrant. If you ask for locations, or if you're just asking for call detail records.
So you could obtain records without locations if locations was not specified in the search warrant.
That's correct.
And let's move to physical devices. So we've talked about a Celebrate report. When law enforcement collects a physical device from someone, and by physical device I mean like a cell phone, what should they do with it immediately upon seizure?
Well, as technology changes and updates happen on cell phones, it is constantly evolving. Practice has been, put the device in airplane mode, and this is to prevent external wiping. Again, keeping it charged. Once that device powers off, it is more difficult sometimes to get the contents out of that device. But again, the technology and the updates are constantly changing. On each update Apple pushes out per se could change the security requirements for us accessing that data.
And for general knowledge, could updates be happening in the background of a device without the user even knowing?
Absolutely.
When you receive that device from law enforcement and it's in airplane mode or whatever mode, that is to prevent signals, essentially like Wi-Fi connection, and then you talked about the actual signals, like the phone company signals. Is that what that's for? Network.
Yes. So the physical device does have the ability to be wiped externally. So we always like to preserve evidence. So that's why we would do these certain steps. And sometimes you could place the device in a bag. It's called a Faraday bag, which doesn't allow signals to transmit to the device. But again, the phone records are based on the network, not necessarily the physical device. It's based upon the tower, the transmission of the records.
And those come from the company.
That's correct.
Does the data sometimes overlap? Can you confirm data from a cell phone record in the phone itself?
Absolutely. They should correspond. Now, a user can delete, a text message or delete a call record. Our technology does most of the time still get deleted information, but yes, absolutely, you should be able to look at records, and if you have a device that hasn't been tampered with, you should be able to correlate.
When you have a physical device, do they say you have an iPhone and then you have a phone like a Samsung phone where it's an Android-based software? Are they going to extract the exact same data from each phone?
Not always. A company, everything's a little bit different in technology. Apple, again, sometimes their next update could require some apps to have Face ID now. Now that changes our ability to extract every single thing out of the phone. Android has different security protocols and updates as well. So, it's not always the same for every single device. And every device could be, iPhone 6 versus an iPhone 16 could have different technology.
So when you receive a physical device, say a phone, what do you do with it once you receive it from the detective or investigator, if you're going to extract it?
So the physical extraction of a device?
Yes.
So I currently do not download devices anymore. There is a team of digital forensic analysts that do such. But I can speak to their processes in which, they, again, try and preserve the best amount of data. And they log, they have their bench notes, and then they physically hook the device to a machine, which is the Celebrate system we spoke of. And it runs you through a bunch of prompts in which it starts the extraction of data and then the decoding of the data, which creates that report.
Once you have extracted the phone in that process and in that manner, do you ever have to use the physical device again?
You don't have to, but sure, you can use the physical device to manipulate it and check your data, spot check it. But the system of Celebrate will let you know exactly what is pulled, so you can verify I did get a report in completion of this device.
So if you have your extraction on the Celebrate on your computer and then you have the physical phone, you can go into the physical phone and verify whether that extraction data is actually in the phone.
Sure.
So some people do that verification.
Yes, and the only exception would be deleted information. It might not be visible on the device, but it will be noted in your report, this is deleted.
Okay, and so when you obtain call detail records, how is it that you analyze call detail records?
So call detail records, again, are given in different formats. That's the theme. And we then ingest them into a software. I mentioned Penlink. So this software reads the record. It reads it, each column and row of whatever record we're receiving. And the system knows the companies and has learned the type of record each company gives. So in which I can set that my time zone is Eastern. So I want to view these records in my time zone of Eastern. So although the records come in UTC time, which is a 4 or 5 hour switch, depending, the system knows that I want to analyze this in a certain time zone and it will convert it for me. Now, in the software, I can go in and I can spot check each row of data and look at the raw record and see. I can add in a column called provider time. So that's going to show me the UTC time zone, for instance, of the record. And then I can show the conversion to my time zone is correct. And again, it gives me another column I can add in call number, and that gives me the exact row on the PDF or the CSV or Excel file to go look at my raw record and compare it to what the software has read.
I want to talk about this case and how you became involved in this case. Can you tell the jury when you were involved and how?
So I was asked in 2018, July of 2018, to analyze some phone records. Again, it was a situation of the investigators wrote search warrants and got the return from the phone companies, opened up the documents, and they're like, I can't read this. We need someone to help us translate this information. So I was given the records and I ingested them into the system and began analyzing them.
Do you remember whose records you were sent?
I was sent various records throughout the course, but I do remember initially I was sent records for Melody Farris, records for Scott Farris. I was sent a tower dump of lots of records for that. And I don't remember if these were all in July. It was over the course of when the phone companies were providing records and when the investigators were writing their warrants.
You mentioned tower dumps.
Yes.
Can you explain what that is to the jury?
So everything we've mentioned so far is sort of individual based. So you can ask a provider, AT&T, I need phone records on this phone number. So that's going to give me all the information based upon that telephone number. If you do what's called a tower dump or a reverse search, it could be called as well. This is asking a specific tower. This is asking each company, AT&T, Verizon, T-Mobile. We want all of the transmissions from this tower during a certain amount of time, a date and time. So this is giving you a wide range of all different phone numbers, not individual based. And it's based upon the location of the towers.
What is useful about that to investigators and detectives when they're looking into a crime?
So tower dumps are used when you don't know who you're looking for, essentially. This is going to give you people's location based upon the location of the tower, who's making calls or sending text messages in a certain location.
Okay, at this time, the state's going to move to admit State's Exhibit Harris 1 and Harris 4 and 5.
All right. No objections.
All right, Ms. Harris, I'm going to pull up what the call detail records you received in this case, just to show as an example. All right, so this is what you received from a phone company, right?
Yes, this is an example of what a Verizon return looks like for call detail records with cell site information.
And I'm going to pull up this third Excel that says cell site incoming, outgoing. So this is what the record looks like when you receive it.
Click the top left box. Go above 81. Click in that box and then expand
don't like it. Anyways, if I were to expand these fields, would there be... I'm going to expand the fields. Let's see. It's just highlighting it.
It doesn't like that big icon. You can't get as fine as you
I should have just... Oh. This is how many records you get, right? Rows of 7,000, 8,000 rows, right?
It obviously varies, yes,
Yes.
based upon the date and time, but it's always large. Most of the time we receive a lot of records.
So I want to talk about each of these, and we're going to look in the field up here since I can't expand the field.
Sure.
So network element name, what is that?
That's, again, something the company categorizes for the area of the network in which the
There you go.
in which the transaction took place.
And then this says mobile directory number, what is that?
So mobile directory number, again, these records are sent with a key within that file, and it will explain to you each field. So here you have exactly what Verizon tells us each field means.
And I'm pulling up historical IP log explanation form within this exhibit.
Well, this is IP. This is
Look, yes, okay. So this is sort of an explanation form. Is that what you're talking about?
yes, this is for the IP data, but
Okay, sure.
they send similar for call detail record. Yes,
This.
exactly. Yes.
Is this what you typically use? The call detail record?
Absolutely. If you're going to look at a raw record like that, raw being the format you saw with all the numbers, this is a very good key to know which each column means. And this, again, is something that the system penlink I use decodes based upon these fields.
And for the record, I'm showing historical call details with cell sites explanation form PDF within this exhibit. So the mobile directory number is the target number. What's a target number?
The target number would be the number that was written on the search warrant for the records.
And then dialed digital number is what?
That would be the number that target number is attempting to reach.
Call direction.
That is either incoming or outgoing.
And then calling party number.
Yeah, this is, again, based upon how you see here, it is whether it's incoming or outgoing. And if you read this here, it's saying, you know, if the call is outbound, the column will be the same as the mobile directory, the target number. If it's, you'll see the called number and the calling party number if it's an outgoing, inbound, sorry.
So seizure date and time is date and time of each call.
Yep.
Seizure duration is the length of the call.
Correct.
Okay. And that's what this Excel cell site incoming, outgoing
Correct.
document that I just previously showed you, that's what this is explaining.
Yes.
Okay. All right, now you mentioned tower dumps. I'm going to pull up an example of a tower dump record. In Harris 4, I'm going to pull up Harris 4, which is the AT&T record. So I'm going to pull up the PDF that's titled Tower Search Records Key. Is this the same type of explanation form that we saw in the call detail records?
It is, just for a different company.
Okay. And then, all right, what are we looking at here?
So again, they come in formats that are not easily understandable. So this is the records of every single phone number that hit a tap, this AT&T network, based upon the location of the towers that were asked for a date range and time. And what's different here than those call detail records we just looked at would be that target number is not the same, because we're not asking specifically for one phone number, we're asking for every phone number that hit a specific tower.
And that way, I mean, what do you do with this? Do you search for a certain phone number if you want to know if someone was possibly making a call during that, in this time frame?
Yes, various ways. I mean, if you know a phone number you're looking for, that would be an easy way to determine if they're in that location at that time. Tower dumps are also used if you don't know who you're looking for, but you know you have two locations. So I want to know if a person, if there's any devices that hit this location and this location in common.